Thanks very much, Tom. Thanks, listeners. Thanks, you all, and good to be back. And I think you'd asked me to give a brief rundown of the EU AI Act and where we were with that at the moment. It's important to remember that despite what you read in the media and despite those tweets that we're seeing that say the act is in and people need to comply, bunkum, it isn't. But the first thing to say, I think, is that AI is not the Wild West in Europe that people think it is. We've already had a number of cases where regulators have looked at AI, usually using GDPR powers. So we've had the suspension of ChatGPT on a temporary basis, an ongoing investigation by the guarantor into ChatGPT, which may lead to a more permanent suspension. We've had the suspension of Replica AI, another chatbot. We've had fines in various European jurisdictions against Clearview AI, a facial recognition operation. And we've also had fines for food delivery apps like Foodino and Glove app in Italy and in Spain. So there's already been a significant amount of regulatory activity. And in most cases, regulators are using existing GDPR principles. So the principles of fairness, lawfulness, and transparency, particularly. And they've been fairly innovative in adapting it. So in the Foodino case, for example, they said that because the algorithm gave preferential treatment to riders and deliverers of food who would work Friday, Saturday, and Sunday, an intentional consequence of that was that the app was racially discriminatory because the Sabbath of most mainstream religions would be on a Friday, a Saturday, or a Sunday. And they also looked at things like the always on nature of a lot of AI. So just because you can get a constant stream of where somebody is using geolocation doesn't mean to say you should. And again, I think with AI, that's one of the real messages. And I know we've discussed it before, but I've been on the NYSBA AI task force. Our report's now out. If anyone wants it, just drop me an email. But we've looked there at more of the should we rather than the can we elements of AI. I mean, one thing that I think Matt's going to talk about that I'm particularly passionate about is that AI, though, because it's difficult, doesn't mean to say that many corporations can opt out. There are clear opportunities with AI. So it isn't a fact of just saying, oh, we won't go near it, because that in itself might lose competitive advantage. So with that introduction, turning to the EU AI Act, reached political agreement in December 2023. It's been a somewhat fraught process. And I think it's always going to be a difficult piece of legislation because, in some respects, the innovation in AI is moving faster than the politicians discussing it. So we saw changes at a very late stage proposed by countries like France and Germany because the pace of innovation was so quick. It's going to be about 2 years until the act is fully in force, but some organizations can volunteer to effectively sign up to the legislation early. This is the so-called AI Act. My suspicion is that there won't be many takers for that. Those that are might be the ones in the deepest trouble. So there's an investigation, for example, into the antitrust competition law aspects of AI. And it might be that a big tech corporation that feels under pressure from an antitrust point of view might elect to join the AI Pact. But for most corporations, they'll have another 18 months or so to prepare. But that doesn't mean to say they should be complacent. Obviously, any AI application that they're building now will have to comply with the legislation if its shelf life is going to be longer than about 18 months. So it's a regulation, not a directive. So the same as GDPR. which means that in theory, the AI Act will be the same across all EU member states. As a side note, it won't apply in the UK. Rishi Sunak's on a long courtship with Mark Zuckerberg, which means that the UK is sort of going light on AI regulation. Some say it's the longest job application in history, with Sunak perhaps thinking that he's out of a job in November, and the election results this morning would have probably hastened that demise. And we'll see him, no doubt, brushing up his LinkedIn profile even as we speak. The Act adopts a risk-based approach. So in simple terms, it categorizes different aspects of AI. And in some respects, it adopts a similar approach to GDPR in that you'll have to do an impact assessment. You'll have to look at the potential ramifications of the AI application that you're bringing in and what you can do to minimize that. Like GDPR, the Act will have extraterritorial reach, and GDPR enforcement will be at member state level. And this is where we're likely to see differences throughout Europe. As I've said already, we've had the Granta in Italy and the AEPD in Spain go fairly heavy on AI enforcement. We've also had investigations in parts of Germany, in Greece, and GDPR enforcement tends to be fairly patchy, and the AI Act enforcement is likely to be fairly patchy as well. I think there'll be a ramp up period. Many of the regulators don't have the technical expertise that they need. So I don't think we'll see big cases initially, but I think we'll see big complaints initially. And if I was a betting man, I'd say that Max Schrems's name will be on some of those complaints. And the fines, again, similar to GDPR, but higher. So fines of up to 35 million euros or 7% of global annual revenue. So the intention is there's quite a lot of meat behind this. Now, of course, for corporations, as I've said, now is the time they're going to have to prepare. I think there are a number of issues. I've looked particularly at the issues around training data. So a lot of organizations have a fairly convoluted supply chain for their AI applications, where they're contracting oftentimes with a big tech company who's then procuring training data to train the AI application that they're then embedding. But there are some real issues there. There's one provider of data called Common Crawl that's a sort of not-for-profit, seems to have the majority of the market in training data. And some of the training data wasn't gathered for that purpose. Things like the replica AI case tell us that there's a lot of unsuitable stuff that's being used to train chatbots. For those of you who didn't follow it, replica AI is the chatbot that basically encouraged youngsters to engage in sexual language and sexual activity, and then was the center of a criminal case in the UK where a vulnerable individual said that replica AI, or his replica AI chatbot, had told him to go and kill the Queen, and he was arrested outside Windsor Castle. So he said, about to follow up on the instructions of his chatbot, and all sorts of particular issues with chatbots like that, and the alleged involvement of the Russian state in some of that activity. So I think it's not an easy job for people to make their AI applications compliant. And of course, for many compliance professionals, they don't know the AI that's being used in the business. And that, again, is an issue that they're going to have to address. So if you're a chief compliance officer, you need to be knocking on the door of the tech team, asking them what AI they're deploying. I'd ask HR and recruitment as well, because from my experience, that's where we're often seeing a lot of AI applications already. And you're going to have to do that diligence, I think, of reaching out to the organization to find out the applications that are already in place and retrofit compliance to them.
Jay Rose, do you have a question for? Actually, I do, and welcome back, Jonathan. These are your EU clients. Are they being proactive or reactive in terms of what's happening in the marketplace?
Yeah, good question. I think the reality is it depends. I know that just before I went away 3 weeks ago, I did a session for one of the world's biggest tech companies that was trying to get ahead of this. And we had a really great session, I thought, looking at some of the risks and some of the opportunities. But other people are behaving ostrich like and thinking, I've got another 18 months, I've got another 2 years, I'll worry about it later. And again, that's a similar pattern that we had with GDPR. There was the sort of deniers and those who thought that they needed to get ahead of it. And of course, there are business opportunities sometimes with getting ahead of it as well. So it's a mixed bag, to be honest, Jay.
Thank you.
Somewhat picking up on Jonathan's Armstrong laying the groundwork for what are the regulatory issues here. And while it's coming out of Europe, I think the structure of the EU AI Act is probably going to be very similar to what we end up with in the United States. So
I think Matt brings up some really great points. And I think one of the things that we're going to have to really take a step back on, as Matt said, is how are the boards going to be able to monitor this going forward? And how does that seep through the organization? I'm going to talk about this in my segment, but there are some groups out there that shall be nameless that are trying to pilot some of this. So it's going to be interesting to see how effective that is. And then I guess my question for Matt is my big fear always, and I think Karen, you mentioned this maybe indirectly or indirectly. My memory's sort of bad these days, but it's if you don't have the right individuals that are responsible for this, and you have this over reliance on artificial intelligence, either at the board level or any other level, I think that's a recipe for disaster. So I just wanted your thoughts.
I think so too. And it gets to yet another fundamental question about board governance is who are you, the board, relying on from management to brief you on what these issues are? And for a lot of emerging issues, I think the CEO is going to try and really keep a very tight spigot on that information pipeline. And he or she will be the one who briefs the board on these things. Even if the board has the wherewithal to say, we want to report on AI, who should that be? Should it be the of IT security? Should it be the chief technology officer? Who's going to get to make that decision? And I think a lot of times the CEO is going to step up and say, you know what? I'll tell you what you need to know about that. I'm very uncomfortable with that idea, but it certainly happens all the time in large companies. Partly because I'm not sure that a lot of large companies have a good grasp on who is in charge of AI development in-house either. So
Yeah.
maybe by default, the CEO is going to do this bad habit. I think it is still a very muddy mess.
Look, I think we still have a problem with people understanding the definition of internal control.
Yeah.
I think the other issue we have is there's a lot of shadow AI as well. Just as we have shadow IT, people in the organization are going out and picking their own solutions. And it's, as I said, it's a really difficult job for the chief compliance officer to know who's doing what. And then you compound it with the fact that most boards aren't appropriately set up to look at the risk. And we've said it on these podcasts endlessly. Boards need to be more diverse. That's diversity of ground, it's diversity of origin, but it's diversity of skills as well. And we tend to have cookie cutter, male, stale directors. And we need to change that. And that's one of the reasons, but there is to declare an interest. Obviously, one of the things and Elevate is to try and look at the next generation of non-exec directors. But there is this real skills gap. I know EY did a survey in 2022 where they said that 35% of boards admitted they lacked an understanding of AI related risk. And 61% of Fortune 100 companies were seeking the cybersecurity expertise on their board. And tech isn't something that boards do well. From my experience, we've had a data breach, for example, where you've got a 70-plus-year-old lead non-exec director who, for various reasons, has to take, control of the investigation. And at the first meeting, I have to help him switch his iPad on. This isn't, these are people who are not digital natives. And if we had a board composition that didn't include anybody with financial expertise, and we said, oh, we leave all that to the auditors and we just trust them, you'd be regarded as a lunatic. And yet we make the same mistakes with having nobody on the board who can assess risk and opportunity with AI, with cybersecurity, with Internet of Things, all sorts of other tech related risks and opportunities for boards. But they've got to get with the program, and boards have got to modernize. It's critical for them.
It's funny, Jonathan Armstrong, your point, if the company just said, we don't do anything about the finances, we just listen to the auditor and what the CFO tells us, not only would you have a big mess, like you'd have the SEC on hold on line one. That is just
Yeah.
horrible. And I do think soon enough, regulators, either in the United States or in Europe, also, if you say something so glib and you're so cavalier with AI, you're going to have regulators for call holding on line two about that lack of oversight. And it is something that I am fully confident most boards are aware that there is a maturity curve they need to get on and get up fast. But I don't know how many of them are going to get up that curve at the appropriate speed, which I think is going to be a pretty high gear. And we shall
Yeah.
see.